Welcome back. Now let's talk about matters Supreme Court and what you should expect from 9 a.m. The Supreme battle here begins at the Supreme Court at exactly 9 a.m. and the final verdict expected on Monday, that's the 5th of September. Let's just get into it, and in studio I have got Wakili Atieno, Ogolla, who is an advocate and managing partner at MMA Law LLP Advocates, who is here to help us just understand some of the jargons and the whatever is happening at the Supreme Court today. Wakili, welcome to the program.
Thank you so much.
I saw you at the Supreme Court yesterday.
Yes.
Or that was not you?
It was me.
What was happening there?
So yesterday we were having the pre-trial conference, and of course I was representing my client, who was an interested party, mentioned in the Ruben Kigame and the Kiamtata petitions. And of course we had the directions from court that said, of course, an interested party cannot be enjoined to the petition as per the Supreme Court Presidential Petition Rules of 2017. So we had to abide by that position, and of course now we will just be watching how the proceedings will be going on. Yes.
It seems that so many interested parties are not enjoined in this case this time around. Why?
Yes, as I've said, the Supreme Court Presidential Petition Rules in 2017 clearly state that an interested party cannot be enjoined to the petition. Okay? So if you're a presidential aspirant, or you're a voter who is aggrieved by the outcome of the election, the best way to actually participate in the presidential petition is by filing a petition as a petitioner, or if you're named as a respondent. Okay, so the jurisprudence that came out yesterday as from the Supreme Court directions is that one can only participate either as a respondent or a petitioner or as an amici. Okay, and an amicus, we of course we know, is a friend of the court who aids the court through their expertise to be able to arrive at a good decision that is favorable to the respondent or petitioner. Yes.
But we all know that friends of the courts play a key role in any petition.
Yes.
Why did the courts in 2017 decide and say no, this time around, no way, only the petitioners?
Okay, of course, we can actually evaluate the circumstances and see, for example, in this petition, the major issue actually is regarding technology. If you heard yesterday when Charles Kanjama, Senior Counsel, was asking the court whether his clients, who are technology experts, can be part of the scrutiny, the court declined and said, of course, their role in the proceedings is regarding just to be able to help the court to understand the issues regarding technology. So the central focus right now is on technology, and you've seen even the 9 issues as framed are revolving around whether the technology deployed was sufficient, whether the uploading of the Form 34As to the portal, there was interference with that. So the major issues are surrounding that, and of course lawyers are not IT experts, and you remember in the last election, of course, the issues still to do with the access of the servers, the algorithm issue was not keenly looked at, and I'm thinking right now the court wants to appear to be fair and employ the various people with various expertise to be able to help the court arrive at a suitable decision. Yes.
So how do courts come up with this somehow a themed version of what to look at? Because each and every person will have their own version of what happened, the transmission, voter apathy, you know, etc, etc. So how do the judges arrive at a thematic area to dwell on?
Yes, of course, you see, first thing, they have to go through the petitions and understand what are the underlying issues, okay? And once you understand the underlying issues, there are cross-cutting issues. There are things which are not in contest, and then there are the contested issues. Now, how they arrive to the final issues to determine are the things that are contested in all the petitions. And that's why you see in the 7 petitions that were consolidated, the Honorable Chief Justice clearly said that the prayers were similar.
They were similar, and they were looking for the same results.
Exactly.
Yes.
You see, so, and of course now you identify what is each party contesting regarding the elections that happened on August 9th. Okay. There's the issue to do, of course, with the uploading of the forms, whether there was voter apathy regarding the places where the elections were postponed, whether actually the person was announced as the president-elect met the constitutional threshold of 50+1, whether the technology deployed was as per the required standard. So all those issues are identified from the pleadings filed, and of course the court has its researchers assigned. So the researchers right now have a heavy duty to be able to read through all the petitions, because one issue the court does not want to appear is to be slack or to be unaware of what the petitioners are raising in the various petitions. So they have to go through them, scrutinize them, and then arrive at the major issues which are in contention. Yes.
It must be a long day ahead.
Yes.
So to speak, the real battle begins at the Supreme Court.
Yeah.
We are likely to see some of the, perennial lawyers, or so to say, taking it to the dock this time around.
Yeah.
Perhaps you can say that even the judges, some of them are experienced. They've been there before, from 2013, when the Supreme Court was established to date.
Yes.
But Chief Justice Martha Koome is sitting there for the first time.
Yeah.
Let me ask you, as an outsider, what do you think is now running through her mind?
Of course, one thing that you should always understand when you're a judge, and of course I'm sure she's aware of, that this is not only a legal issue, but there's also politics at play. So even as she's trying to see on how best to handle the issue, she understands the atmosphere that Kenyans are in. Kenyans are right now anxious because they don't know whether they have a president who they can term as a current sitting president, or whether the decision of the court will affect the outcome, therefore maybe resulting to a rerun, whether there will be change of guard. You see, all those things. So as the president of the Supreme Court, I'm sure she has all these intervening factors in her mind. And of course, she knows that the history of Kenyan politics and Kenyan elections, and of course, how Kenyans have resulted to seeking electoral justice through the courts. After post-2007, through the Kriegler report, one of the major issues, that came up is that we should embrace electoral justice systems. So Kenyans have decided this time not to go to the streets. I think this is one of the elections where we've seen Kenyans really restrain themselves after the elections. Okay, so she's cognizant of the fact that the decision that will come out of the Supreme Court will
have a ripple effect either way.
Yes, either way.
Yes. So
of course due procedure has to be followed. Everything that the petitioners and the respondents are bringing out has to be considered in light of the law. So I'm sure she's very keen to ensure that as the first in her first term, or her first time handling a presidential petition, she appears to be fair, because we say in law justice should not only be done but be seen to be done.
Yes.
So I'm sure she is cognizant of all those factors.
You can imagine you are going out there to Mama Mboga. She doesn't understand what's happening at the courts, or our friends out there, the border guys, they're not aware of what's happening at the courts.
Yes.
One question that people do ask me, Victor, kwani tutarudi kwa debe? Ama unaona koti inaamua aje? I'm like, boss, I have no idea. So what basically should we look at on 5th of next month?
You see, Victor, it's hard to actually predict the outcome of the court. In cases before the court, it is based on evidence. Okay?
Yeah.
Our Kenyan legal system is largely adversarial. The one who has the best evidence wins. Okay? So what can be the outcome, for example, if the presidential elections, the presidential election that was held on August 9th is upheld? Of course, the president-elect declared will be sworn in, and of course, government will be formed, and the other processes continue. But then, if the elections are nullified, of course, we'll see whether the Supreme Court will direct that fresh elections be held, or one of the prayers I've seen in one of the petitions was that the person who was declared as, or rather who should have been declared as president, be given the certificate. Okay, so there are various outcomes that we would expect, but it's solely dependent on the evidence that will be presented, the oral presentations that will be made as from today, and how the judges will use the law to be able to marry them with the facts and actually arrive at a decision.
Yes. Can a Supreme Court decide and say, okay, we've heard you, thank you so much, ka huku. So this is what we're going to do. Because of candidate X got this and candidate Y got this, the winner is this. Can the Supreme Court say that?
Not actually, because you see, one of the issues that have been framed today, as you've seen, is whether the president-elect or either of the parties attained the 50+1. Okay, so one of the issues that have come up in the prayers of most of the petitions is whether the irregularities actually affected the results. If the Supreme Court is able to find that the irregularity affected the results, then actually it can show that there was no clear winner, then a fresh election be held, because then the process was not as per the constitutional threshold. Okay, we know that the Constitution provides of how a free and fair election should be held. So if the procedures were not upheld, and that's what came out clearly in the Raila 2017 case, that due procedure is important. You cannot only say that election is free and fair because voters lined up, they voted peacefully, but what about the verification and the tallying? And that's one of the also major issues that the Supreme Court will look at. It was the verification and the tallying process after the election as per the constitutional threshold. Okay,
we cannot have 100% positive results in an election, even in the US, other jurisdictions. But what is the margin of error that the court will be looking at? Because there should be plus or minus to say, okay, much as we cannot get 100%, I think we did this.
Yes, of course, we acknowledge, of course, that there cannot be perfect elections. Even the US elections, there were issues of hacking.
Yes.
But, of course, there are the various procedures which should be followed. And if you look at Section 39 of the Elections Act, it says that the National Returning Officer, who's Chebukati, in this case, is allowed to announce results before all the results have been received, if he has reason to believe that the results which have not been received will not affect the final tally. You see, so those are the certain measures which have been put within law that, of course, we know, yes, there are various issues regarding elections, and, of course, we understand the technicalities, but then if you have reason to believe that the results which have not come in will not affect the final tally, then you can announce the results. So the issue is, and I think that's why we had the 4 commissioners talk about opaqueness.
Yes.
They do not know them as commissioners, and it's going to come out clearly.
Was that their reason?
No, I'm saying, for example, in their statement that they said that there was opaqueness during the final stages of tallying. So maybe they were referring to, or which I do not know, we will see through the evidence that is presented, whether the results that had come in last, they were to significantly affect the final result. You see, them they said, as per their statement, which I remember correctly, that they were not involved in the final tallying, therefore they do not fully know that the outcome of the results from the, I think it was between 27 or 20 to 30 constituencies. So if we look at those constituencies and see that those results could not affect the final tally, then we can have reason to believe that indeed the president-elect was duly elected. But if those results are tallied and they bring the margin of different, let me say, nature, maybe now it shows that maybe Raila should have won, or both candidates have attained 49 and not that 50+1, then you know that, of course, could actually be a ground to nullify the election and order for a rerun. So what I'm saying basically, Victor, is that the evidence presented, and of course we know there's the scrutiny that's going to happen, that is also going to show whether there were irregularities during the polling cycle. So all those things will actually help the judges arrive at which decision is best.
Yes.
Okay.
Yeah.
But the Supreme Court is allowed to nullify elections, to uphold an elections, and also order for a rerun.
For a rerun.
Yes.
3 circumstances.
Yeah.
Okay. In your own perspective, what do you think is so different in this sitting starting at 9 a.m. compared to the previous petitions?
Let me say, if you look at this current petition, of course, it came out yesterday that in the previous petitions, there were fewer petitions that have been filed. This time, there are many petitions that have been filed regarding the same issue. And of course, it shows that many people had an interest in the person who's going to be president. That is very clear. Yeah. Okay. And also, one other issue that, let me say it's not a difference, it's a similarity. We are still seeing the major issue of technology. The technology deployed by the IBC during elections, and I think now it has to bring up serious discussions whether technology can really deliver free and fair elections, or which type of technology then should we use.
Exactly, that is what's the question. In fact, most people are saying we are deploying technology left, right, and center. In 2017, we used the KIM system kits. This time around, only a paltry number of 200 just failed. Now, that's a small number compared to 46,000, 229 polling stations.
Yeah.
But then, IBC should now, based on what you're saying again, the kind of technology should be deploying in an election. Then where are we as a nation?
I think for me, the major issue then now, if we look at the technology, it's now the security of that technology, okay? Because there's something called digital footprints. You're able to see who accessed what at what time. And you see if the servers are also analyzed, you're able to see whether there was unauthorized success. So maybe the technology could be okay, but are the security measures enough? Yes, exactly. Yes. And for me, one thing I'm looking at also maybe is exploring the idea of using blockchain technology in elections, because blockchain has showed that it has minimal security breaches. And of course, because we know elections are managed not only by technology but by human beings who in Kenya have shown that they don't have ethics. You see, so we cannot police, we cannot use the law to impart ethics on people. Then let's ensure that our technology is tamper-proof, so that if anyone tries as much as they would like to interfere with the technological processes of elections, then it is minimized. Okay, so the major actually similarities is just that the issues are largely the same, but the issue of technology still runs through, and the players are the different people. And of course, we are seeing more advocates participating in these election petitions. So I'm saying that the major issues are the same, but the issue of for example, the tallying being final at the polling station, I think that was settled in the previous election, so that is not an issue right now. Okay, so at least there are.
So the problem starts from the tallying from polling station now to the main tallying center.
Yes, yes. And if you look at one of the issues that has been framed is whether the Form 34 is uploaded at the portal were the same ones from the polling station.
Yes.
Okay.
Yes.
So one thing I've noticed in Kenyan elections, the issue is never about the voting. Once the tallying and the verification begins, that's where all hell breaks loose, because people fail to follow down the laid down procedures. For example, at the polling station, if agents are supposed to sign and supposed to ensure that the various processes have been followed up to the constituency tallying center, then now to the national tallying center. So it's the processes after the voting that actually determine whether an election is free and fair. And of course, we know in Kenya and everywhere around the world, politics is about numbers. So anyone can manipulate the numbers to favor them, and the numbers count during the tallying at the polling station, and then from the polling station to the county, or rather the constituency tallying center, then the national tallying center.
Wakili, let me just ask you, based on what you've said, voters will wake up at 3:30, 4 a.m. to go and line up and vote.
Yes.
They'll do their civic duty and say, Mimi nimemaliza. I still have my ink, by the way. I voted. But the question someone will say, why do I have to go and vote if my vote will not count? Because I will cast my ballot, and then in between the process something happens. Therefore, my number or my vote will be rendered so, quote unquote, useless. Do you really think politicians have this in mind, that Kenyans will go to the ballot every 5 years, but then they will feel demoralized to go back again because they feel we voted, but our voice was not respected?
Actually, now it puts the burden on the professionals in terms of the lawyers and the legislators to ensure that the electoral laws favor the, let me say, the insight of the voters. Because you see, it's towards the elections, like about 8 or 12 months, so that we see many amendments to the electoral laws coming. And one of the ways, of course, elections are governed is through the laws themselves. How do we ensure that each vote will count? We have to look at our laws. Do they actually uphold or favor a free and fair election? Okay, because one thing that's coming out right now, and even we saw in the Mombasa and Kakamega gubernatorial elections, there was voter apathy. People are asking, will their vote really count? Will, of course, the tallying be tamper-proof or happen according to the laid-down procedures? So I think there is need actually to look at our electoral laws and review them. There is need for the IBC, or rather, let me say, stricter penalties to be imposed on those who actually infringe on those electoral laws, from the returning officers to the presiding officers and all the staff, IBC staff engaged in managing elections. There should be stricter enforcement mechanisms so that people can know that if you fail, you've been trained and you fail to actually carry out elections as per the law, then you're liable in a certain way. Okay, so I think Kenyans can only have trust in the electoral body when the electoral body actually plays by the rules. And that's why I'm saying procedure is everything. If you, even in employment law, for example, if you fire an employee without following the procedure, the employment court will still find you as an employer liable. Okay,
you know, that not because you're talking about procedure and I don't want to be found liable. Let's take a break by my employer. Let's just take a break. We still have so much more. I have got Atieno Ogolla, who's an advocate of the High Court. We still need to understand many things, even as we head to the Supreme Court, where the battle will begin at 9 a.m. Let's take a break. We'll bring back. Okay. Okay, all right, welcome back. Trying to get some legal jargons here. I've been called amicus. Oloo. Welcome back. My name is Victor Oloo, and I still have Atieno Ogolla, who is an advocate of the High Court. We are still understanding what should be happening at the Supreme Court. Of course, it's fully packed. 3 days or 4?
Yes, 3 days.
3 days.
Yes.
So to speak of the timeline, the real battle begins today.
Yes.
And it will run until Friday, when the judges will retire to make their ruling and judgment to be delivered on Monday.
Yes.
But then there is this version of the timeline that is given by to the Supreme Court constitutionally. Do you think is enough?
It could not be enough, yes, but the nature of a presidential election, we cannot put Kenyans at bay for so long, you see, and that's why generally election petitions have very stringent timelines. But of course, the presidential election petition is given that short amount of time so that normalcy can be resumed as quickly as possible. And because we saw even when Kenyans were waiting to hear who was the president-elect between the 7 days which the national return.
Impatient.
Exactly. You can imagine now if you extend it to 21 days for a presidential election petition to be determined. I think people will be, I think Kenyans have really shown us that they're very impatient people. So, of course, the constitutional provisions actually understand the nature of a presidential election and the stakes that are involved. Then the constitution just gives them 14 days, and the time could be short, but of course this is the time that the Supreme Court judges get to work a lot, because we know that not all matters on appeal in general cases are allowed to be at the Supreme Court. Yeah. So the time is limited, but it's of importance.
It's okay.
Yeah.
This is the second time. The first one was in 2017 that the petitioner was granted that access to access the servers of IEBC.
Yes.
This time again, Raila Odinga, who is the main petitioner, have also been given that leeway to access the servers, quote unquote, and to verify votes from different polling stations. Do you really think this is an indictment to the IEBC?
You see, one thing that I've said previously, that we have shown that we don't trust our systems, our constitutional bodies, okay? And if someone is alleging that there was issues to do with the uploading of results and how the people who accessed the various technology were not authorized, then we have to open up and see, because you see, transparency is one of the electoral principles of the electoral system. You see, if there is a doubt as to the transparency of the elections, then let the burden be on IBC to show us that indeed there is no issue. Okay? So I think, you remember in 2017, the IBC really did not want to open the servers. I hope right now they will. And of course, if they show us that there was no issue, then we can start trusting them. You see, but if they show us that, or they give us even reason to believe that there could be doubt or there could be the infringement of the various principles, then of course let them actually be the ones to show us that everything was conducted as required.
Wakili, there was a case of the representation for the 4 dissenting commissioners at the IEBC, and the court said, you know what, that's an internal issue, you have to deal with it.
Yes.
What does that really show?
Okay, you see, there are various procurement procedures to be followed when you're listed to represent a parastatal, okay? Then that's why if you saw the learned senior counsel, the former Attorney General Githu Muigai, say that as per those procedures, he is the one allowed to represent the commission, okay? Then how can the 4 commissioners put some other advocate to be representing them who was not listed to be among the people to represent them? So what the court was trying to say, we cannot come and involve ourselves in the internal procedures regarding representation of a parastatal, because there are clear laid down procedures on how one arrives at the advocate to represent a parastatal.
Yes.
What they said then, these commissioners, maybe in their own individual capacity, can procure the services of Senior Counsel Paul Muite and Issa Mansour. Okay? And I think that was the best direction to go, because it would have been absurd to have 2 advocates representing the same body, and yet of course we know there are already clear divisions.
And then there was an issue of them coming as individual commissioners or as collective commissioners of IEBC.
Yes.
What was dealt with by the court yesterday?
And I think if you look at what the directions of the court were, is that they could actually procure the services of these other advocates, but on an individual capacity, because they cannot purport now to act on behalf of IBC and procure the services of this commissioners.
Yes.
You see, so, and of course this is one of the issues that actually will come up during the petition, whether of course as the 4 commissioners they are still the majority and can decide on certain things, but let us see how it will play out in court.
Are they petitioners or respondents?
There are respondents in part of the cases, but if you remember what one of the advocates raised is that how they responded, it sort of raised other issues that they could have raised in a petition.
Oh, yes.
You see?
Yes.
So, of course, we'll see how the court will handle that issue. But in major of the petitions which were consolidated into one, they were respondents. They were all listed as respondents in their individual capacity and as a commission. Yes.
Okay. Let's go back to what I asked in terms of what's a bit different, because this time around we are seeing only 4 lawyers will be given time for the petitioner, and the respondents will also get 4. And of course, other interested parties will get number of and lawyers. But the main players here, the petitioner and the respondents, will get 4. This is a complete departure from what we had in the previous 2 petitions in 2013 and 2017. What necessitated this?
Of course, we know how lawyers have a boss. Okay. Verbose meaning that they are very generous with words.
You're talking about yourselves. Okay.
Yes, and the reason I think in her wisdom the Chief Justice did that is because, as I've said previously, the issues being canvassed upon are largely the same. Okay?
Yeah.
And right now, of course, there were a lot of, let me say, procedures to be adhered to. For example, there's a scrutiny, which after the conduction of that scrutiny, they have to evaluate the report. You see, so there are various issues that they need to consider. And I think it was best if they, of course, still allow the various petitioners and respondents to be represented as they would wish, but limit the time so that a petitioner's advocate can converse on the major issues and not go giving stories. We heard about in the previous, let me say, 2017 election, there was an advocate who was saying, giving different analogies. Let me not say it because, of course, we could know who it is. Yeah. But we want to narrow down to the major issues and arrive at a decision as soon as possible. Yes.
There is this word, the law is very clear.
Yes.
We hate what I think even a class 3 pupil will tell you. The law is very clear. We are seeing a different face of the Supreme Court. 3 learned ladies and 4 men on this end. Of course, that's an odd number.
Yes.
All right. What do you think the personality of CJ?
The personality.
When the mic is on and when she speaks.
One thing I have loved about her, and it was very clear from yesterday, she is in charge of her courtroom. And that is very important because sometimes, let me say this as a woman, sometimes people would feel that they can intimidate you to sway. And of course, you see, if you understand the process of a trial, there's also the psychological war and the emotional war that someone could wage on someone, maybe on the bench, or we know there are counsels who are known to be bullying the bench. You know them. So, of course, she clearly showed she is in charge of her courtroom. One thing I also liked, she showed that she has set down rules, and anyone who does not abide by those rules cannot be accommodated. For example, in the directions, when one of the councils had requested that more advocates be allowed to act, the clear directions from the GCJ was that they will not add more advocates to any party. That clearly shows that they are going to follow a procedure and they have stick to that procedure, even in terms of the people being admitted into the courtroom. If we said it was 4 from the beginning yesterday at the pre-trial conference, that's how it's going to be all through. But of course, in due consideration to the fact that now they've said the commissioners can decide whether to be represented individually, so they will factor in that in today's hearing. So I like that she has shown she's firm, she's in control of her courtroom, she's trying her best to adhere to the laid down procedures, and she's also accommodative. We saw how, despite the fact that Professor Wajakoya was not a party to actually give an oral presentation, she allowed him to make his grievances heard. You see, that's actually part of what a fair trial constitutes. You see, so she's really trying her best to show the Kenyan public that they can have confidence in the Supreme Court of Kenya, and that is very important because when anyone is aggrieved, they run to the courts. They run to lawyers. So Kenyans should see that we can trust our processes in the judiciary, and as the president of the judiciary and the Supreme Court of Kenya, she is exuding confidence in Kenyans.
Wakili, there are 3 things here. There is law, there is democracy and governance.
Yes.
And when you look at Kenya, Kenya sits at a very advantageous position in East Africa or even globally.
Yes.
Do you really think Kenyans are treating such kind of processes? For example, we go to an election is contested, we go to the Supreme Court, as was like in 2017, it was nullified, people went for another cycle of election. Do you really think Kenyans really appreciate this as a growth of democracy in our country?
I think they do, because if you compare with some of our neighbors, people say Kenyans, we have a lot of freedom. And I think also they have come to appreciate that in some other African countries, and we saw Kenya was the first African country to annul a presidential election.
Absolutely.
So of course that put Kenya on the map, and Kenyans really did see and did appreciate that in Kenya we have laws that are starting to work for us. If they doubted, now they saw. And now of course that's why Kenyans even have maintained their calm after the elections. If they did not have faith in the Supreme Court, they would have gone to the streets as has been the normal occurrences.
Right.
But they have been told to keep calm by both divides, and they have decided let the courts decide on who was the rightful winner and if there were any irregularities or what was the outcome of the election. So the conduct of Kenyans in these elections has shown that they have faith in the democracy that we are struggling to grow. Of course, there's still room for improvement, but it shows that there are gains, and our constitution is actually working for us, and we actually do not really need to amend our constitution, but to fully implement it to the latter.
Which is something that is still under process, and you know, even the drafters of the constitution said that, well, we've done our bit, but we'll still need more time to fix some of the loose ends. You look at Kenya, we have got some brilliant brains, yours here included. I'm told that even international jurisdictions procure lawyers from Kenya to go and work for them in other cases.
Yes, that's true. That is very true. And even in the sitting that is going to be happening right now from 9 a.m., you have Commonwealth judges who are coming to benchmark and see how we are conducting our processes. So of course that really shows that Kenyan brains are really sought for out here. So we owe that to, of course, the various law schools in Kenya and our training as advocates.
Okay.
Yes.
All right, let's talk about the issue of the 9 issues here, what the Supreme Court will decide. One of them was the technology, verifiable, secure, and transparent. That is one of them, something you talked about. So it's based on technology.
Yes.
Okay. In 2017, it was about the transmission of results.
Yes.
Number 2 is, well, Form 34 is intercepted before landing in the IEBC public portal.
And that's also technology.
Technology. Yes. The third one is whether there was a difference between Form 34S on the portal and the Form 34S received at Bomas.
That's now transmission.
Transmission.
Yes.
Okay. The fourth one is whether the postponement of gubernatorial election in Kakamega and Mombasa counties resulted in voter suppression. Well, this is something that I want to talk about, but I don't want to make your judgment or just prosecute the case. But it's something that we also discussed here with other guests in studio, that a lot of voters were disenfranchised in some sort of way to bring what we saw yesterday as voter apathy. For example, Mombasa has around 800,000 registered voters, but what we had yesterday was around 200,000. What is your take on that?
You see, as much as we would want to run away from that conversation, the truth is the voter turnout was not as expected.
It was bad. It was bad.
Yes.
Right.
And you see, one thing that could have largely influenced was the postponement of the elections. Because you see, at that time when the elections were postponed for these specific positions, Kenyans in all other parts of the country were voting for their 6-piece electoral positions. So, of course, we cannot deny the fact that there could have been, let me say, change of mindset when these elections were postponed. And of course, now looking at even the outcome of the of the results, could it also have affected the psychology of the voter? You see, so there are many issues at play here which we cannot ignore. Of course, we will only maybe say that it has happened and we take the lessons, but we see that certain actions during elections affect the voter turnout, and during, before, and after. Okay, so that would be my take on that.
Okay. The next one is whether there were unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions.
And just allow me to comment on that. And that is a very important issue which I was discussing with some of my colleagues. You know, it beats logic. For example, a voter entering into a polling station, taking the 6 ballot papers and deciding that they will not vote for 5 of the electoral positions and only vote for the presidential position. You're getting that scenario.
Yes.
So that's why we were trying to ask ourselves, could it be in some areas that is what really happened?
Yeah.
And of course that will come out maybe during the scrutiny, and that's why the scrutiny will be important to understand what were the patterns of voting, what was really happening at the polling stations. Is it in some areas people only deciding to vote for the president alone, or others were deciding to vote for the other position? So that's a very important.
It's a very important point.
Yes.
And if my memory serves me right, the same question arose in 2017, where it was CJ Mwelu, DCJ Mwelu, and was it, I think, Smoking Wanjala, who asked if you're given number of votes, ballot papers, 1, 2, 3, 4, 5, 6, and you decided to say, I'm going to vote for candidate X, where do the rest of the papers go?
Exactly, and you see now that's what is the big question to everyone.
And it was a big issue. I remember most of the legal minds were like, you know, the ballot paper, this and that, some of the issues that were being raised. Again, in this one, do you think it would have affected the results somehow?
Yes, because you see, for example, even the reverse could happen. Someone decides to vote for the 5 positions but declines to vote for the presidential position. So then does it also show us that a person declining to vote is also exercising his constitutional or political right that he's choosing not to exercise it? You see, so there are various issues that especially this issue that will be of keen interest to understand the psychology of the voter or what really did occur at the polling station.
Okay, last but not least, whether IEBC verified, tallied and declared results in accordance with Article 138(3)(c) and 138(10) of the Constitution.
Yes.
Okay. Those are some articles that I don't understand. I don't know what you mean by that Article 138(c).
Of course, you see, and I've been clearly saying it, that there are various procedures laid down by the Constitution on how results should be verified, tallied, and finally announced. You see, we know that the first thing that should happen is all results, the Form 34As, are received at the National Tallying Center.
Physically?
Yes, the physical forms. And if you look at one of the issues actually to be determined whether there is a difference between the Form 34As uploaded and the physical one, if you look at Section 39 of the Elections Act, it says where there is any discrepancy, it's the physical form that will be upheld. And you see that's a process of verification.
Yes.
So once we have received this Form 34As at the National Tallying Center, we verify them. Okay, then we look at the Form 34Bs, which were from the constituency tallying centers. Okay, whether the Form 34As are for the specific constituencies actually tally with the Form 34Bs. Then the Form 34Bs are used to collate the results into the Form 34C.
Yes.
Okay.
Which is now used by the
Chebukati. Yes, to announce the results. So that procedure, if it is not followed or if there are major discrepancies, then you see that can affect the outcome of the results. And that's why the Supreme Court, as a court listening to a presidential election petition, is allowed to nullify an election if the irregularities are so sufficient to affect the outcome of the results. That's why in law, procedure is everything.
In law, procedure is everything. And finally, whether the declared president-elect attained 50% plus 1 of all votes cast in accordance with Article 138(4) of the Constitution. Yes,
and you see that is very important because we have previously talked about the National Returning Officer, the National Returning Officer Chebukati being allowed to announce results if there are some results which have not been received, and he has reason to believe that they will not affect the outcome of the results.
Yes.
If we look at now these results, which we do not know what they were, if we look at them keenly and we see that no one attained the 50 plus 1, then what does it mean? That there was no clear winner, and then that's how the Supreme Court can arrive at a decision of a rerun, so that we can determine who was the clear winner of an election. So it's very important to understand that that constitutional threshold will set a very important, let me say, magnitude in this case, so that if there was no clear winner, we'll go back to the ballot.
And that is one of the prayers by the main petitioner, Honorable Oloo, who says he wants the court to declare him as the winner. Can the court do that?
Yes, of course, if there is sufficient evidence that will show that he was the winner. And you see, that could be maybe through the scrutiny or through the various evidences that will be presented. But I think the Supreme Court will largely decline to do that. This is my honest, let me say my perception on that, because you see, if the evidence is not sufficient to maybe make them declare such ruling, then they will actually give other alternatives that could still maybe arrive at the same outcome. So on declaring a person as the president-elect,
that will have to go back to the IBC.
Yeah, it's a very tall order, you know.
Yes.
And the Supreme Court does not manage elections in this country. You see, so I think also they will try to check what are their mandates as a court, and what is the mandate of the Electoral Commission. Yeah, so that they do not overstep, even as they try to create precedents and jurisprudence from the court.
Yes.
Yes.
Okay. I think we've exhausted the 9 areas that the courts will be dealing with. So far, we can bring them down. It's about technology, the process, that's the law of, I mean, the verification, and the 50% plus 1, that is the constitutionality, and the postponement of that case, whether it affected.
Actually, those are the 4 major issues.
The 4 major issues.
Yeah.
So let me ask you this particular question as we come closer to this one. Do we really have a situation where Kenyans appreciate the fact that court plays a key role in determining how an election should be held in this country? Do we really have to be going to the Supreme Court each and every electoral cycle? Or it should be one touch and we're out?
You see, Victor, that's a very difficult question to answer, because now that brings in the element of electoral justice. Okay? You see, if someone is aggrieved by the outcome of the election, where should they run to?
Where should they run to?
Yeah, exactly, and that's the court. So, and we've already said here clearly that elections can never be perfect. So if someone feels that the elections are not conducted in the constitutional way, or if they feel that they are aggrieved, there should be a recourse so that we ensure that whenever an issue arises regarding the outcome of the election, there's a clear laid out channel to which that issue can be actually channeled. Okay, but the major issue, and I think I've been saying that as Kenyans we have deep ingrained mistrust between us and the electoral body. You know, we can continue disbanding these electoral bodies, but if these people who are there do not adhere to the various laid down procedures and constitutional thresholds, then there will always be that culture of mistrust. Yes.
I know you'll be sitting somewhere watching. Will you be at the Supreme Court?
Today, maybe in the afternoon.
In the afternoon?
Yeah.
What should you expect? In the next 25 minutes, the sitting will begin.
Of course, the petitioner is the one who begins.
3 hours?
Yes. And we saw the battery of lawyers. And the one thing you should also note, in the consolidated petition, there are a number of petitioners apart from the apart from Raila and Martha Karua. So the councils will also, these other petitioners will be given an opportunity to address court.
Yes.
Okay. But the main petitioners, their councils are the ones who will begin.
Yeah.
Of course, they will address court on the major issues, the 9 issues. Now they will they'll have to address court on the 9 issues.
On the 9 issues,
they cannot now start compounding.
Even in the consolidated cases?
Yes. You see, once the court consolidated the various petitions, it now said these are the 9 issues which we are going to adjudicate upon in this court. So any presentation that will be made today will be largely within these 9 issues. You see, because if the court left it to the advocates to decide which issues, they would talk about everything and anything concerning elections in this country. But these are the major issues which actually can help the court decide whether the election was held in a free and fair manner. Okay? So the petitioners begin their case, the advocates argue out their case, then the respondents are given their chance. Maybe tomorrow we'll see how the timings will play, and that's why I love that the CJ was very strict with the timings. Then there's a rejoinder where the petitioners now can answer to what the respondents have said. And of course, the various court assistants, the other assisting staff at the present within the hearing will be assisting to take notes, because you don't want to misinterpret what anyone said.
Yes. Okay?
So, of course, that's what will happen moving forward.
It must be a very difficult moment for legal minds right now, because you'd imagine the number of cases, and this one you have to do this, you have to fix that loophole, we don't want to lose a case. Are you happy to be a lawyer at this particular point?
Let me say, I've always been happy to be a lawyer, because you see, it's at this time that lawyers are able to show that they actually support the Constitution and its mandates. Okay? And it's at this time that actually lawyers are able to show their skills better and display them. You know, sometimes some clients refute from paying lawyers. They think that they can actually do these things on their own. But you see, actually, representing a client is a very tedious task, because you have to think for the client, you have to read the law, you have to see which evidence is in support of your client and which things that would hinder your client's case from progressing forward. You see?
No, that's a lot of work.
Yes, it is a lot of work. And you saw the lorry of evidence that was presented when they were filing the petition.
Yes.
You see, so lawyers have to ensure that all these things have been adhered to, because at the end of the day, sometimes if you lose a case based on technicalities, the client will blame you. But we thank God our Constitution says that justice will be administered without undue regard to procedural technicalities. And that was shown yesterday. And of course, that's now showing the attitude of the court, that they want to appear to be fair, because you saw the DCJ allow that some affidavits which had been filed out of time, but so long it was not after 2 p.m. yesterday, they were to be admitted. And though the people who are to respond to those affidavits will not respond in a written format, they have permission to respond orally.
Right.
Okay?
Yes.
So that is already showing that the court really wants to be seen to have done justice in this matter.
Okay. I will ask you this question, because when you see the learned friends sitting there at the bar, and they want to, the future of this country squarely belongs to them right now, not to the politicians. It's up to them now to decide. What do you really think now this portrays to the young and upcoming advocates who would want one day to sit at the bar? Talking of, people want to be, judges of the Supreme Court. You'll answer that. But let's talk about the judges, the four men and the three ladies, their vast experience. It's not the first time this is happening in Kenya. In 2017, we went for an election. Some of them were there. CJ Maraga, of course, now already out. But do you really think this one put them in a very tricky situation, because now they'll have either to nullify or uphold an election? Do you think it's a pressure to them?
I mean, they know what their job comes with. They know what they signed up for.
Yes.
So even if, yes, there is pressure, they understand the duties that they owe to this country, as now sitting as the Supreme Court judges, who are now being told, decide for us if this election was free and fair. You see, they understand the magnitude of their decisions. They understand the pressure that the work comes with. And I think for me, they are up to task. Because you see, like someone like Justice Lenaola was previously at the Constitutional and Human Rights Division. You've seen of course, the various judges also have various experience in other courts, other higher courts like the Court of Appeal. So, of course, they understand the magnitude of what their work comes with. They only can just do the best that they should do.
All right. As we come to a close to that, what now thinks is a picture to the legal minds who are also climbing up the ladder to be where they are, including you?
I think one major lesson, and I think not only to us legal minds, that Kenyans should understand, there's a large intersection between law and politics. Okay? And as a lawyer, if you're not aligning yourself to certain political stands, maybe it will be hard for you to also get business, because it's some of these politicians that have legal work. Okay? And apart from that, politics is also affected by the laws of the land. You see, so they intertwine in very many different ways, but now lawyers understand how they should be at the forefront in championing, for example, legislation review, because they're the ones who are trained to study the law. And if these laws fail, it's the lawyers who are practicing on the same law. So they should actually engage in legislation review. They should actually be at the forefront in championing for democracy, because if rights are infringed, lawyers are still the people who are renting.
You are quite familiar with that corridor?
Yes.
All right.
Yeah.
That is Milimani, if I get it right. That is Milimani Law Courts, just at the entrance down the stairs where will be the action will be taking place. That's Milimani Law Courts. Live pictures there.